All right, so maybe we'll just get started and people will join us as they come. I'd like to welcome everybody. My name is Nick Custer with the University of Michigan Flint's Innovation Incubator. We're happy to host this workshop today, and we were very appreciative of our guest speakers, the Wayne State University Business and Community Law Clinic. This is a group that we bring in each semester when we can. These are student lawyers, student attorneys. This is part of their requirement on their way to graduation through the Wayne State University's law program. We're also joined by Professor Rachel Setlich, Director of the Clinical Education Program, and Min Jian Huang Esquire, pardon me if I misspoke at all on that, Clinical Program Staff Attorney. This is our first webinar, and so we're excited, a little bit nervous to the technology issues we might face. So we just ask you guys bear with us. For the sake of the presentation, so we don't have any extra noise in the background, I just ask that if you're not speaking, you just keep your microphone on mute during the presentation today. If you do have questions as they come up, you can put them into the chat, and hopefully our attorneys will be able to answer them as they are put into the chat box. And then I think there'll be time at the end for us to actually ask questions over the video chat as well. So with that, welcome everybody to Forming Your Business and Legal Issues for Returning Citizens and Entrepreneurship. I'd like to just have the students kind of introduce themselves and get us started.
Good afternoon, everyone, and thanks for joining us today. I am Josh Mulick. I am one of the aforementioned student attorneys, and collectively, we wanted to begin by giving our sincerest thanks to our community partner, the University of Michigan Flint Outreach Program, and to their assistant program manager, Nick Custer, for making this virtual presentation possible amidst the ongoing pandemic. While we had hoped to present in person at the Ferris wheel, we are grateful for the opportunity to offer this webinar in its place. Today, all of us on behalf of the Wayne State University Law School Business and Community Law Clinic will be presenting Forming Your For-Profit, Nonprofit, or Social Enterprise with the special topic of legal issues at the intersection of entrepreneurship and criminal justice. Collectively, the Business and Community Law Clinic this semester is comprised of seven student attorneys, as Nick mentioned. 5 of us are in our second year of law school, and then there are 2 of us in our final year of law school. And you will be hearing from all of us at different points in this presentation. We are led by our supervisor, Ann Choike, who is unfortunately unable to be with us for this webinar, but in her place, we have our staff attorney, Min Huang, and our director of clinical education, Rachel Setlich. Just to briefly correct something Nick just mentioned, if anyone has any questions throughout the presentation, we ask that you please document them as they arise, and we will actually be accepting questions relating to the presentation via email at bclclinic@wayne.edu. We intend to respond to all questions as soon as we are able to, and there will be a reminder of this fact at the end of the presentation. We just ask that to give us time to appropriately respond to any questions and to consider some of the issues that you may have in listening to us, that we have the time to commit to properly giving you the correct feedback. Without further ado, I will pass it to Michael Carty, who will give us the introductory agenda to our presentation.
Hi, thanks, Josh. And my name is Michael Carty. I'm another one of the student attorneys working for the BCLC this semester. And just to take you through a brief agenda to outline exactly what we're going to be talking about today. We are going to start off, it's broken up into 3 parts. The first being an introduction and overview of exactly what the BCLC does for the community and for its clients. Then we will go into part 2, which talks about entity types and formation, and followed by part 3, which is our special topic, as Josh touched on, being returning citizens in the workforce and combating barriers to reentry. We kind of broke that part down into both focusing on the returning citizens as entrepreneurs and also focusing on organizations engaging those returning citizens. So turning to part 1 of our presentation, just kind of going through a quick introduction to the Business and Community Law Clinic. So one of our main focuses is community advocacy. And what we mean by this is engaging in the Detroit community and Michigan community in general to try to help some social enterprises and try to help their work within the community. A social enterprise is an organization that can be for-profit, nonprofit, or some sort of hybrid that uses an entrepreneurial and or equitable strategy in order to pursue outcomes that are not only financially oriented, but also positively impact employees, other stakeholders, the community, the environment, and much, much more. And now I will hand it off to Taylor to talk about some of the transactional services that the BCLC is able to provide.
Great, thank you, Michael. So our clinic offers free transactional legal services to qualifying businesses and social enterprises in Michigan. We help these organizations with entity formation, document drafting, corporate compliance, and other transactional services. Some examples of clients we've worked with in the past include a social enterprise committed to empowering formerly incarcerated women by providing employment, as well as a joint venture of 2 educational organizations in Brighton that operate a community workshop. Moving to the next slide, we are here today to provide general legal information on entity structure and social enterprise, as well as the specific topic of engaging returning citizens in the workforce. Accordingly, today's communications are not confidential. While we will be taking questions via email at the end of the presentation, we also cannot provide legal advice specific to anyone's particular issue or situation. I'd now like to hand things over to Meredith, and she'll begin talking about our discussion on entity structure.
Thanks, Taylor. Hi, guys. I hope everyone's doing well today. So I just want to go into a little bit on entity types and formation. We're going to sort of cover the types of entities that we think would be beneficial for you guys starting your potential business, or if you already have a business and you're thinking about forming it as a legal entity. Next slide, please. So basically what we need to go over first is what an entity is. So as a person, you have a separate legal identity. And what an entity is it's an organization, usually governmental or a business, and that has a separate legal identity as well. And as you'll see throughout this presentation, that has different advantages, tax advantages, things like that that could help you throughout your business. Next slide, please. So a business entity is an organization that is created by one or more persons, and it focuses on the structure of the entity, not the actual business operations that the business is carrying out. And businesses are formed at the state level, which means you have to file, you may have to file paperwork with the Secretary of State, but you must comply with the state laws of which you are operating your business in. So today we're going to cover the state entity laws of Michigan and Delaware. First, Michigan, because we live here. I do want to go over some of the tax advantages of Michigan, though. So there's certain rebates and incentives that they have for energy products in Michigan. For instance, Consumers Energy provides basically rebates and incentives to businesses who upgrade to efficient lighting, kitchen appliances, refrigeration, laundry, HVAC equipment, and insulation. And through this, there's a $1.80 tax deduction, I think, for each square foot of those who install those things. Also, there's a work for opportunity tax credit for giving high-risk employees a chance to be a part of your team. And so basically what this is that employers who hire targeted groups of people and who have had past experience of getting hired, having difficulty with that, they have a chance to earn a living. And through this, you get a work from opportunity tax credit. Next, we're going to move into the Delaware laws. The reason we decided to involve Delaware laws today is because Delaware is highly known for having basically the most flexible business laws in the country. For instance, Delaware investors prefer Delaware corporations because of things like the fact that Delaware has a court that focuses exclusively on business law. And in this court, instead of having a jury, you have 3 judges who hear the cases, and they are well versed in business law. So you kind of know what the outcomes are going to be, or how you need to approach your case within that court. Also, there's attractive tax advantages. For instance, if you are incorporated in Delaware, or if your business is set up in Delaware, but you actually conduct your business in Michigan, you don't have to pay the Delaware state tax. And additionally, those investors who hold stock, those investors who are not Delaware residents who hold stock in Delaware businesses do not have to pay the Delaware taxes. Next slide, please. So these are the types of business entities that we're going to cover today. You know, they go everything from independent contractors to nonprofit corporations and unincorporated association. Next, I want to hand it over to Josh, who's going to talk to us a little bit about independent contractors, the three types that we have here today.
Thank you, Meredith. So an independent contractor is an individual or business who performs services to another individual or business pursuant to a contract between them. Independent contractors are distinguishable from employees who regularly work for an employer. Now, the distinction of employees versus independent contractors is an important one for any business who seeks to make such a distinction. In separating the two, the classification may depend upon 1, the level of control, 2, the investment in the facilities or the tools used in the trade by the company and the worker alike, 3, the opportunity for the worker to have separate profit and loss, 4, the permanency of the relationship, and 5, the required skill of the worker. Now, these factors are important to consider when determining whether your worker is an employee or an independent contractor, because governmental and regulatory bodies such as the Department of Labor and the IRS have a special interest in that classification. As Meredith mentioned, we will be discussing 3 types of independent contractors today: informal, formal, and nonprofit. An informal independent contractor, is an independent contractor with no formal written contract. It is akin to what we might call a handshake agreement. For example, if you have a handyman, somebody that you don't necessarily have signed paperwork with, but there is a mutual understanding that he will perform services as necessary. A formal independent contractor is one that has an official written contractual agreement between the independent contractor and the person or entity seeking their business. This is more akin to an employee while still having the separate classification that I mentioned previously. Now, finally, a nonprofit independent contractor is one that has a contractual agreement such as the formal independent contractor. However, in this case, it is with a nonprofit organization, thus creating the distinction between the prior two. Now, there are some advantages and disadvantages to classification as an independent contractor. Some of the advantages are they are easy to form, and there's no special paperwork to be filled out other than IRS form filings, which most often are the requirement of the independent contractor to fill out, such as you think of your tax statements. An independent contractor may have to fill out a 1099 form when filling out their taxes as opposed to a W-2 that they receive from their employer. Some of the disadvantages, however, are significant and not always considered. The misclassification that I mentioned previously has significant tax repercussions. The IRS will actually assess back taxes and assess past benefits to any independent contractor that has been misclassified as such. So if they were under that test that I mentioned previously, found to be an employee for a period of time existing prior to that investigation, then the employer would have to pay back taxes and other certain penalties as a result of that. And finally, another disadvantage is the exposure to potential liability. The independent contractor specifically would have a large exposure to liability. So that'll conclude our discussion on independent contractors generally. And now I'd like to pass to Taylor to discuss specifically the sole proprietorship.
Great, thank you, Josh. So a sole proprietorship is actually not a separate legal entity separate from the business owner. So for those of you that may not have access to the slides, I'll read off the definition we have here. And so a sole proprietor is defined as a business owned by a single person who has not filed paperwork to operate the business in some other legal form. So working from this definition, this is actually the default entity designation for any individual doing business. Therefore, if you're operating a business on your own and you have not filed any separate entity status, you would automatically be considered a sole proprietor. Now, the main advantages of this structure are the lack of formation requirements and the complete management authority granted to the business owner. On the other hand, though, a sole proprietor is personally liable for any and all of the losses of the business and also may be sued in their personal capacity for issues arising out of the business. Now I'd like to hand things over to John, who will discuss our next entity.
Thanks, Taylor. So I'm going to talk about Michigan General Partnerships. So the definition of a Michigan General Partnership, it's a for-profit business with 2 or more owners. These are the partners who have not filed paperwork to operate the business in some other legal form. So there's no paperwork requirements. You don't have to go to the Secretary of State. This is just 2 people coming together to start a business. So it is a separate legal identity from yourself. However, you don't have the liability shield that some other entities may have. Advantages: you're not required to pay federal income tax at the partnership level. You still have to pay your personal income tax. But if the partnership makes money and it's not distributed to yourself as payroll, you don't have to pay tax at that partnership level. Also, if you are at a loss in a lawsuit, the winner of that lawsuit must exhaust all of your partnership assets before going after your individual personal assets. So they can't take your money until they take all the partnership's money. However, when I talked about the liability shield before, that's where we come into one of the disadvantages, meaning even if they do exhaust the partnership's assets, they can still come after your personal assets in a lawsuit. So now I want to hand it off to Michael, who's going to tell you about LLCs.
Thanks, John. So an LLC, or a limited liability company, is one of the more popular business structures in the last few years. So the LLC is a for-profit business that owners have filed the articles of organization in their state's Secretary of State. In Michigan, that department is called LARA, L-A-R-A, or the Michigan Department of Licensing and Regulatory Affairs. Now, the entity itself creates a separate legal identity from the transacting individuals. Like John said, this means that the company itself has a separate identity and can be sued or bring cases on its own, separate from the transacting individuals. Unlike the general partnership, one advantage of the LLC is that it does provide a liability shield. This means that the personal transacting individuals cannot be held liable for the debts of the company, with few exceptions. But another advantage of an LLC is the flexible governance structure. Unlike some corporations, there's no annual meetings, no board of directors, and no election of officers that are mandated by statute. Additionally, it allows for funding from traditional sources like banks, investors, and more. And then another advantage is the flexible taxation. LLCs are able to elect different tax status and can be treated both as a partnership or as a corporation for tax purposes. One disadvantage is that it is slightly more difficult to form than a sole proprietorship or a general partnership because you do have to file with the state. However, that's relatively easy, and the liability that it provides the owners is well worth the filing. Now, an L3C, or a low profit limited liability company, is another form of an LLC that offers advantages for businesses whose main purpose is not to generate profit. So this is kind of a form of one of those social enterprises that we had mentioned earlier. An L3C files the same paperwork as an LLC with the state, but includes a statement of purpose. And that statement of purpose, it has 3 parts. First, it significantly furthers the accomplishment of one or more charitable purposes. Second, the production of income or appreciation of property is not a significant purpose of the company. And lastly, the purpose cannot be to accomplish one or more political or legislative goals. Now, the benefits to the L3C are that it can attract socially conscious consumers and investors, and also attract nonprofit organizations looking to invest in a social enterprise. A disadvantage is that it does not itself allow for tax-exempt status, but again, it can attract the certain investors that are able to use their tax-exempt status, such as other nonprofits. And now I will hand it off to Hannah to talk about a benefit corporation.
Thank you, Michael. So as Meredith mentioned in her introduction, we're discussing entity formation, not just here in Michigan, but also in other states like Delaware. So a Delaware benefit corporation can most closely be compared to the L3C that Michael had just introduced to us. It is a for-profit business, it's a corporation, but it has a defined public benefit purpose within its governing documents and within its activities. This means that the corporation does not solely exist for the purpose of creating profit to reinvest and distribute to shareholders, but that it also contributes that profit and that net revenue to its stated public purpose. Much like other corporations, it is a separate legal identity, and it's structured the same as traditional corporations would be as well. When forming this type of corporation, you must file in the state of Delaware with the Delaware Division of Corporations, and in your certificates of incorporation, you must state specifically that this is a Delaware benefit corporation. It's important to state this to be able to have this classification, and any stock that this kind of corporation issues must also identify itself as a public benefit corporation and identify the public benefit that it is seeking to achieve. Some of the benefits of these types of corporations are that they allow the corporation to circumvent that mandatory distribution of profit to shareholders and allow it to promote a public good. Companies that promote these kinds of social goods are attractive not just to consumers, but also to investors who are looking to support these socially conscious types of corporations. B Labs is a certification organization that can certify companies that incorporate as such entities as a Delaware benefit corporation as a B Corp. And while this B Corp certification is more for social purposes and becomes attractive to consumers and investors, it is not treated as a separate type of incorporation under tax purposes. And that's one of the disadvantages of these Delaware benefit corporations, is that they're not eligible to receive the tax benefits of a nonprofit corporation, meaning that they're not eligible to elect for 501c3 tax exempt status. Now, moving on to the next type of entity, JJ will be taking over.
Thank you, Hannah. So a Michigan nonprofit corporation. This is an organization that is formed to serve the public good, such as for a charitable, religious, educational, or other public service reasons, rather than for the pure creation of profit. This entity has a separate legal structure. And so what this means is that the persons transacting or the board of directors cannot be held liable for the debts and liabilities of the business. The formation requirements include filing articles of incorporation with the Michigan Department of Licensing and Regulatory Affairs. And again, it must be formed for public benefit. And what this means is that it cannot be organized or operated for the benefit of a private interest or individual. So none of its net earnings may benefit a private shareholder or individual. And the last formation requirement is that it is restricted in political and lobbying activities. What this means is that the organization cannot carry out any activities that are aimed at influencing legislation or advocating or opposing any political campaigns. And some of the benefits of forming a Michigan nonprofit corporation are that organizations that form this type of entity typically enjoy an exemption from corporate income taxes on the profits from their activities that are related to the organizational purpose. And the way that you apply for a tax exemption as a nonprofit corporation is with Form 1023. Also, another benefit is that these corporations are permitted to raise funds by receiving public and private grant money and donations from individuals and companies. And tax laws actually encourage people to donate to nonprofit corporations by allowing donors to deduct their contributions on their tax returns. And lastly, as I said before, the nonprofit status protects its directors, officers, and members from personal liability for the company's debt. And now to talk about some of the disadvantages of forming a nonprofit corporation is that it takes a lot of time, effort, and money to apply for incorporations and a tax exemption as a 501c3. And also, the activities of the organization are very much limited, and it has to be dedicated to the public interest in some way. And so this means that all of their filings, federal and state filings, will be open for view to the public, and the public may scrutinize it in some way. And so next, I'd like to get into Michigan unincorporated, nonprofit unincorporated associations. So a Michigan nonprofit unincorporated association is a group of 2 or more people who consent to form an organization to carry on a lawful purpose, not for profit, but for a charitable or educational or religious or scientific purpose. One of the notable differences with an unincorporated nonprofit association is that there is no separate legal identity from the transacting persons. So this means that there is no protection from personal liability from the debts and liabilities of the organization or association. With the formation requirements, there are no formation requirements, and an unincorporated nonprofit association may qualify for tax exempt status if it makes less than $5,000 in annual revenue. That means if it makes less than $5,000 in annual revenues, it may function as a 501c3 without applying for IRS recognition with Form 1023. However, it may be difficult to obtain contributions and donations without an IRS determination letter officially recognizing the nonprofit as a 501c3 organization. And also, again, it must, in order to qualify for tax exempt status, the association must provide that no part of its earnings will contribute to the benefit of a private individual. And also, there are limitations on political and lobbying activities under a nonprofit unincorporated association. Can't participate in any political campaigns, and no substantial part of its activities can be related to influencing legislation. Some of the benefits to forming a nonprofit unincorporated association are that they can be formed pretty easily, and they're typically used to accomplish limited short-term goals, such as raising funds for a library or another short-term project. There are no filings with Laura. However, some of the biggest drawbacks with incorporating or with pursuing the nonprofit unincorporated association is that that there's no protection of personal liability for the people, the directors and officers of the association. And also, since there is no separate legal entity status, the members have to enter into contracts in their own names. They can't enter into contracts under the nonprofit unincorporated association's name. There are some states that do allow unincorporated associations to enter into contracts with a separate legal identity, such as California. And the legal mechanism by which they do that is through an enabling statute that grants rights to entities to hold and receive property and sign contracts in its own name. However, Michigan does not have one of those enabling statutes. And so that's it for Michigan nonprofit unincorporated associations. And next, I'd like to talk about our special topic, returning citizens in the workforce and combating barriers to reentry. And so some of the topics covered are going to include returning citizens as entrepreneurs, which deals with lack of access to resources, the intergenerational effects of incarceration, dealing with substance abuse and mental health, the legal considerations for faith-based institutions. Another topic is organizations that are engaging returning citizens, the financial incentives for hiring returning citizens, negligent hiring and anti-discrimination compliance, and company and culture solutions. And so on the first topic, lack of access to resources, Some of the notable examples of how returning citizens lack access to resources are transportation, vital records, literacy, workforce development, and expungements. And some of the ways that we can work to combat this lack of access to resources is through the local government, the city council, who has a returning citizens task force, and they host meetings that typically occur on a quarterly basis. They get input from the community, and they hold workshops that are aimed at connecting vendors and other people who seek to provide resources with those people who are looking for those resources. And next, I'd like to talk about occupational licensing. And so a lot of people out there might want to start a business or might want to get licensed as a barber or a hairdresser or a nurse or in public health or other skill or get another skill. And some of the stigma related to returning citizens who have been recently released from prison or jail is the felony conviction box. A lot of a lot of licenses will require that you check the felony conviction box if you've ever been convicted of a felony. Another obstacle is the good moral character checkbox, where a lot of licenses that you can apply for will require that you check the box that says you have good moral character. And but just because an application for a license might have that box on it that you have to check for felony conviction or good moral character, that does not necessarily mean that a criminal record will bar you from obtaining licensure or registration. Even when the application does include a felony checkbox or a good moral character checkbox requirement, the Michigan Department of Licensing and Regulatory Affairs will make a case-by-case evaluation of whether the person is able to obtain that license or not. And this determination includes factors such as whether the offense that the person committed relates to the license or registration that they're seeking, how much time has passed since the conviction, if there is any evidence of rehabilitation, as well as other circumstances. And so everyone who applies for a license and is denied is entitled to a rehearing if they have new evidence to present. And so some of the licensing programs that require the felony checkbox and the good moral character provision are the public health, the licenses that are regulated under the Public Health Act, the Public Health Code. Any license that you apply for under the Public Health Code is going to require you to check the felony conviction box or the good moral character box. A lot of the licenses under the Occupational Code require good moral character, but not necessarily that you check the felony conviction box if you've ever been convicted of a felony. And a lot of the licenses regulated under the Skills Trade Act don't require the good moral character and felony conviction box. And so obviously the question is, what are these licenses that are regulated under these different types of laws? And so for a comprehensive guide on every occupational license that is offered in Michigan, you can go to this link that is included on the slide, www.michigantalent.org, returning citizens. So that's it for occupational licensing. Next, I want to talk about obtaining state-issued ID and other interactions with the state. And so it is common knowledge that state identification is essential for employment, housing, or other benefits. Usually when you apply for a job, when you apply for housing, when you apply for food stamps or anything like that, they're going to ask you for an ID. And most commonly, people leave the custody of the state when they're getting out of jail or prison. They don't have a state ID. And a lot of the reasons is because it might be cost prohibitive. It might cost too much to get a state ID, or it just might be very difficult to obtain the necessary documentation that you need to obtain a state ID. Um, and so, just to break down what documentation is needed to obtain a state ID, is that you need one document proving your social security number, one document proving your citizenship, one document proving your identity, and two documents proving your Michigan residence. And so, how do you prove your social security number? Obviously, with your social security card or a W 2 form or a tax return. Um, one way, a few ways to prove your legal presence, your citizenship, is a passport, a birth certificate, or a Michigan enhanced driver's license. One way to prove your identity, a few ways to prove your identity, again, a passport, any other type of license or ID card from out of state, a marriage license, a divorce decree, an employee ID with an employee photo ID issued by the federal or Michigan government agency, or Michigan Department of Corrections prisoner ID. So if you're getting out of prison and you have your prison ID still, you can submit that to the Secretary of State as proof of your identity, and that will count as one of the documents that you need to get your state ID. One way to prove your Michigan, or a few ways to prove your Michigan residency, is a utility bill or a credit card bill issued within the last 90 days, an account statement from a bank or financial institution issued in the last 90 days, Michigan high school, college, or university report cards or transcripts, a mortgage, lease, or rental agreement, pay stubs or other earning statements issued with the name and address of you or the employee, life, health, auto, or home insurance policies, or federal, state, and local government documents such as receipts, licenses, or assessments. This includes your title and registration for your car as well. And so those are a few ways that you can prove. A few ways that returning citizens, a few documents that they can obtain in order to prove their identity, prove their citizenship, their residency, and a social security number, and get a state ID. Some states do allow inmates that are getting out of prison to simply exchange their prison ID for a state issued ID. But Michigan is not one of those states. And so, yeah, that's about it for obtaining state issued ID. And I'd like to turn it over to Meredith to talk about the intergenerational effects of incarceration.
Thanks, JJ. Okay, so I'm going to, as JJ said, I'm going to speak a little bit about the intergenerational effects of incarceration. As you can imagine, there are many negative implications that come from family members being incarcerated or currently incarcerated or previously incarcerated. For instance, about 1 in every 100 adults in the US is incarcerated right now, and that puts us at about 2 million children who have an incarcerated parent. So with that, I would like to focus on the exclusion of young adult children who have had or do currently have an incarcerated parent. And I would like to talk about how to combat those negative effects. So social exclusion is basically something that hinders a child from normal societal activities. And what this is it precludes them from activities such as access to information, recognition, and identity, and it gives them an eroding self-respect when it comes to achieving their capability or knowing their capabilities and achieving personal goals, and basically what correlates with the American dream. So this correlates into all the negative implications that I'm going to be talking about in the next slide. So father incarceration effects correlate really a lot with expulsion and suspension in younger ages. But when they get older to the young adult child stage, it really correlates with low personal and household incomes. For instance, individual incomes for young adult children who have had or do have incarcerated parents is usually under 42,000, and a combined household earning is usually around 68,000. Now, to go on to the mother, the incarceration affect young adult children in the fact that they have lower college degree completion rate than most children who do not have an incarcerated mother. It also gives them a sense of powerlessness. And basically, what powerlessness it gives them a sense of feeling that they can do little things to change the important things in their life, like their socioeconomic status, where they're at in their job, their family mobility. And they feel like there's really no way they can change it. So they basically feel like they don't have any power over what they can do with their lives. And so combined together, the mother and the father incarceration effects on young adult children, it creates low socioeconomic mobility, it compromises their education, and it constrains the family mobility in a way that makes it so the family as a whole has a hard time moving up the socioeconomic ladder. Next slide, please. So there's a couple of ways that we can combat the negative effects to these young adult children, and try and really help them out in a way that hasn't really been done before. One of the examples is community outreach. These can be done through things like groups that give children support, get them involved in activities that requires responsibility, dedication, work ethic, respect, etc. And so something like, a YMCA sporting group could give them that sense of opportunity and community outreach that they need at a younger age. Next is the remedial educational interventions. So there's schools that have higher parental incarceration rates. For instance, in Detroit, I know there's a pretty high amount of schools that have a high parental incarceration rate. And so results of the study that I've looked at show that those who did get more educational experience or attention after their parents were incarcerated had fewer negative effects than those who did. And lastly, this must be done with a sense of urgency. Basically, the sooner the intervention takes place after the parent is incarcerated, the better off the child is going to be. And that way, we can combat the negative effects earlier in life so they're not having the effects that I talked about in young adulthood. Next slide, please. There are also some legal tactics to combating these negative effects. For instance, you as small business owners or potential small business owners could hire a returning citizen. You could work with local precincts and parole officers to let them know that you're a potential employer who wants to work with returning citizens. Don't judge if the criminal history box is checked on the application, and conduct criminal background checks later in the interview process rather than immediately. Another way is comply with wage garnishments. Wage garnishments help pay off things like child support of a garnished employee. This is a common legal implication for returning citizens because while they were incarcerated, they were unable to pay things like child support. The garnishment is sort of a burden to the employer, and a lot of employers do not want this a financial burden. So recently, Michigan has actually alleviated the administrative costs of wage garnishment. In 2015, employers now get $35 for a wage garnishment instead of $6. And although it seems counterproductive to take money from the wages, it guarantees that the money goes into the requisite obligation for instance, like child support, like I mentioned, and therefore you're contributing to the actual financial resources that a child may need to succeed. So that is a way to help those negative effects. And lastly, next slide, please. The most important thing is just awareness. We need to be more socially aware, more socially conscious about what's going on in our neighborhoods, such as Detroit and Flint, and try and reach out and help your neighbor, help a stranger when you can. Provide those opportunities if you are a small business owner to those returning citizens comply with those wage garnishments, and see if there's any community outreach you can do for these young children. Next, I want to get it over to Michael, who's going to talk about the issues of dealing with substance abuse and mental health.
Thank you, Meredith. Now, obviously, substance abuse and mental health are a huge issue and a big problem in the workplace. The key to a strong substance-free workplace is positive culture and a practical, supportive policy. Now, this is accomplished by both responsibilities of the employee and the employer. Starting with the employees, just knowing that it's an ongoing process is very important. Substance misuse, education, prevention, and recovery are all ongoing processes that take a lot of work. By both thinking of different educational programs and encouraging your workplaces to enforce them and implement them, you can create an environment that is conducive to a productive workplace. Next, it's important for employees to know your rights. The ADA protects those that are in recovery from a drug addiction and who are not currently using drugs at the time of their employment. So an individual who is currently engaging in the illegal use of drugs is not covered by the Americans with Disabilities Association, but employers may not discriminate against a person who has had a history of drug addiction but is currently not using illicit drugs. Now, turning to employers, the key to success of a drug-free workplace policy is building programs that are going to support that policy. An effective policy is accomplished by positive workplace culture, which is sustained by employers who practice, follow, and espouse the policy themselves. Workplace leaders must show support and set the right tone for their workplace. Employees need to understand the rationale for the policy and the program in ways that are practical and going to be meaningful to them and their own job responsibilities. A lot of what employers can do is work with human resources in order to implement policies that are going to create a positive workplace environment. Reviewing the workplace's policy, programs, and rules with new hires and existing employees. And as new hires begin work, make the review part of their orientation package, including it on company intranet and internal websites so that there is open access to those documents. Discussing how employees and their families can get help is important. Many times these issues or substance abuse and mental health do not stop at the individual, but can be part of an entire family or social or society. And so explaining how employees can get help through different employee assistance programs, health and wellness programs, employer-sponsored healthcare coverage, and other channels is important. In addition to that, discussing prevention sources such as health and wellness programs, helplines, and other community resources can be very beneficial. And lastly, partnering with local organizations is oftentimes a great tool for companies to use. There's a lot of private and public organizations in every community that will partner with businesses to provide a lot of these services and resources. And employee education, as always, is very important. It's important to strive to show how healthy habits can elevate performance. And again, coming back to the key of a strong substance-free workplace being positive culture and a practical supportive policy, creating an open and supportive environment is more important than anything. By having a supportive environment for employees to be open about any sort of issues they may be dealing with the employer, you can create channels and be able to assist them by connecting them with the resources they need to both better themselves personally and also help them perform at their highest possible level in the workplace. And now I would like to pass it off to John to talk about faith-based institutions.
Thanks, Michael. So I'm going to talk about the legal considerations when working with faith-based institutions. So there can be a lot of benefits to working with a religious organization or a faith-based institution, but there are some potential consequences that we should all know about. This isn't to dissuade you from working with your local religious organizations. It's just to inform you that the rules and the laws might be a little different for them. So just as a brief overview, there is something that's known as the church autonomy principle. And this may exempt religious organizations from a lot of well-established laws. And today we're going to focus on this church autonomy principle, how it affects hiring practices and fiduciary duty, and then how to form a successful partnership with your religious organization. Next slide, please. So first, the church autonomy principle. As many of us know, the First Amendment has created a separation between church and state. This means that religious organizations have the right, and we have the right to be free from government controls regarding our religious affairs and the internal affairs of religious organizations. And the Supreme Court even took this one step further in the late 1800s. There was a case known as Watson versus Jones, where the Supreme Court said that courts can't interfere with religious decisions. This means that religious organizations, their decisions of faith or custom must be accepted as final by the courts. So if I'm a faith-based institution, I'm a religious leader, and I make an internal decision within this religious organization, the courts have to accept that as final. You can't fight it. So this has a lot of benefits. It keeps the government out of our religious organizations, but it has some unforeseen consequences as well. Next slide, please. So the big carve out, the big consequence that the church autonomy has is what's known as ministerial exemptions. Ministerial exemptions are exemptions from well-established laws due to the church autonomy principle. For example, based on the church autonomy principle, Congress exempted religious employers in the Civil Rights Act in 1964 from all complaints of religious discrimination. This exemption allows them to give preference in hiring to candidates who share their faith or religion. Also, recently, some judges have even refused to interfere with religious organizations who have dismissed LGBTQ individuals or unwed mothers, even if they profess the same faith, because they violated their employer's religious codes. Additionally, religious organizations could be exempt from fiduciary duties. Now, a fiduciary is a person who is required to act for the benefit of another person on all matters within the scope of the relationship. Normally, this is about financial advice. So a good example would be your accountant, a financial advisor, someone of the like. So generally, when providing advice, a fiduciary, such as an accountant or a financial advisor, has the duty to act with good faith, loyalty, due care, and provide full disclosure. And if they violate one of those duties, they don't act in good faith, they're not loyal to you, they don't provide full disclosure with their advice, you may have a legal recourse. You might be able to bring a breach of fiduciary duty against that accountant or financial advisor in court. And you may be able to make a claim and seek some money as compensation for your damages. So while religious leaders may also be great business people, they may have their own businesses outside of their church or religious institution, and they might provide financial or business advice as well. They might not have the same fiduciary duties if the advice that they provide was based on their religious belief. So they could say, based on my faith, I think you should invest your money here. I think you should start your business here. And maybe they didn't act in good faith. Maybe they did, but maybe they didn't provide full disclosure. Maybe they didn't do their full research. And in that case, you might want to bring a fiduciary duty claim against this religious leader, faith-based leader, because you could have a business loss because of the bad advice that they gave you. Unfortunately, because of the church autonomy principle, Michigan courts have disallowed breach of fiduciary duty claims against these religious organizations if those claims are related to religious guidance. However, it's important to note that these exemptions only apply to religious decisions. If the advice was secular or not religious, not faith-based in nature, they may owe you that fiduciary duty when providing that advice. Next slide, please. So there are these exemptions. There's exemptions for hiring practices and exemptions from breach of fiduciary duty claims, but that shouldn't dissuade you. That shouldn't discourage you. Religious organizations are powerful, important members of the community, and they do a lot of good, and they can help you do a lot of good with your business. And even in 2014, President Obama made a request that all agencies remove bureaucratic barriers for faith-based organizations that are committed to assisting their communities. So the federal government's been working hard to break down these barriers between local businesses, community organizations, and the religious organizations in the community that could help them really get a jump start on things. And the federal government even has a Center for Faith and Opportunity Initiatives that provides resources on how to form successful partnerships with your religious organizations in your community. And if you go to the Department of Labor's website and look for Centers for Faith and Opportunity Initiatives, that's www.dol.gov/CFOI/. And they're going to have a lot of great resources for you there. They're going to have short articles on how to form a successful partnership with your local faith-based and religious organizations, and give a lot of great advice on how to get the ball rolling. So now I am going to hand it off to Josh, who's going to talk about the financial incentives for hiring returning citizens. Thank you.
Thanks a lot, John. So now I want to discuss some of the financial incentives for hiring returning citizens. I want to preface this section of the PowerPoint by saying that some of these considerations can help as it relates to part 2 of this presentation with regard to entity selection and entity choice, because in a lot of scenarios, we discuss some of the tax advantages and disadvantages of certain entities. And by incorporating some of the financial incentives available for hiring returning citizens, the tax advantages or disadvantages of a particular entity may not be as significant of a concern. So you can use that to kind of offset some of the burdens in some cases. Some of these advantages include the work opportunity tax credit, bonding programs, which includes the federal bond program and fidelity bonds in Michigan. And then finally, I also want to briefly discuss some of the soft factors that might influence the bottom line of your business when you're hiring returning citizens that maybe we don't consider in the same light because it doesn't create a specific monetary value. Beginning first with the work opportunity tax credit, the WOTC is a federal credit available to private for-profit employers who hire from a specific targeted group of people who have had experience in the past and difficulty in securing employment. In the first year, it allows a $2,400 credit for any individual hired from a targeted group. These targeted groups include ex-felons convicted or released within 1 year of their hire to your business. Now, there's also tax advantages to this beyond the credit that you're given. The credit can be carried back 1 year, or it can be carried forward 20 years from the year of claiming the credit. That is to say that if you don't have sufficient income to offset the credit or in the specific year that the credit is earned, then you can carry it forward 20 years until a point when you can claim the credit in full. So there is that tax advantage built into it. The WOTC does have some specific requirements. There's an IRS form that they use to pre-screen the applicants to make sure that you are hiring from a targeted group. And further, there is an Employment and Training Administration form titled Individual Characteristics form that you list following the hire. So it's two kind of descriptional forms that you have to fill out with regard to this person you're hiring. And also, there may be a need for additional documentation based on the discretion of the regulatory agency. Further, once certification is secured, the for-profit employers have to file 2 specific forms of their tax returns. Those are forms 5884 and form 3800 with the IRS. Finally, when you file for a work opportunity tax credit, you will file that with the unemployment insurance agency in Michigan, specifically addressed to the WOTC unit. I want to briefly touch on bonding. While my classmate, Hannah, who is following this part of the presentation, will discuss it further, I wanted to provide some of the highlights. So the federal bonding program began in 1966, and it provides fidelity bonds to employers. These bonds target individuals whose backgrounds present significant barriers to securing and or retaining employment, including justice-involved citizens. So this is the justice-involved citizens is the corollary to the Work Opportunity Tax Credit's targeted group. It specifically addresses the individuals returning to the workforce. How it works is it protects an employer as to losses caused by certain acts of individuals that are hired under this bonding. They are received free of charge and will cover the first 6 months of that employee's employment. Within Michigan specifically, we have a fidelity bonding program that provides the same protections. It covers losses from $5,000 to $25,000 during the initial 6-month period. And it comes with its own requirements that I believe Hannah will discuss further. One of the more specific is that the employee must be a full-time worker for 6 consecutive months. And that covers the bonding section that I wanted to briefly touch on. And finally, to kind of highlight the fuller picture of the financial incentives, I also want to touch on some soft factors. Beyond financial gain, hiring ex-offenders presents other advantages that are not commonly considered. The first being loyalty. Ex-offenders tend to be loyal to the employers who are willing to hire them. Because many of them are truly changed by being in prison, they will have a much greater chance of succeeding on the outside when society is willing to accept them. And that acceptance can be in the form of an employer who gives them a job opportunity that they would not otherwise receive. Second, you have crime reduction. Getting a job is crucial to successful reintegration of ex-offenders into society and to the promotion of public safety through crime reduction. As a corollary to crime reduction, we also have cost reduction. The annual cost of incarceration in Michigan is about $35,000 per prisoner. The annual budget for the Michigan Department of Corrections is over $2 billion. By reducing crime and reducing the cost of incarceration throughout the state, that money can be best used in other ways that will benefit the economy as a whole and the businesses that are situated within that economy. So to say that to summarize, it is essentially a benefit to not only yourself to hire an ex-offender because of some of the factors that they bring individually, but there's also the benefit of the economy at large that will have some effects on your bottom line that you may not see in the same light as you would some of the other things I've discussed. And finally, just some other employer benefits. Most recent ex-offenders are under the supervision of a parole or probation officer who can also be a contact person and a resource for the employer. The officer can address obstacles to employment, such as transportation and counseling. And many ex-offenders have access to job readiness and skills training as part of programs being implemented in prisons and jails alike nowadays. Now, I want to segue into my classmate Hannah's part of the presentation, where she will continue some of this discussion as well as some adding to it.
Thank you, Josh. So businesses who are looking to hire returning citizens may have concerns about their liability, both when it comes to hiring workers with a criminal history and on the opposite side, if they choose not to hire workers who have that same criminal history. And starting with that second category, we have a few relevant laws for employers to be considering if they're concerned about violating anti-discrimination laws or clauses. At the federal level, we have Title VII, and here in Michigan, we have the Elliott-Larsen Civil Rights Act of 1976. Both of these laws protect against discrimination in the workplace on the basis of race, color, sex, religion, or national origin. One of the categories that these two statutes do not cover against, however, is criminal history. So there's no protected class based on justice system involvement or criminal history that employers can be concerned about violating if they choose not to hire returning citizens. One statute that employers should be aware of, however, is the Fair Credit Reporting Act of 1970. This act creates a federal requirement for the use and dissemination of criminal background check information as well as credit checks in the employment process. Employers are obligated to provide notice to applicants that this check is being performed. They have to receive written consent from the applicants against who the checks are being performed against. And if employers decide not to hire an applicant, say someone with a criminal history, they must give notice to that applicant stating their intent to not take this decision not to hire them, and allow 5 days response time for the applicant to try and dispute any inaccuracies in the report or contest the reason for the negative employment decision. Moving on to the next slide, On the opposite end, instead of employers being concerned about not hiring candidates, they may be concerned about hiring returning citizens and their liability risk if something were to happen after employing these citizens. So one concern for any employer who's looking to hire an at-risk worker is this liability risk that stems from the acts of their employees. Negligent hiring is one of these concerns, and that's a cause of action by someone against the employer for the harmful acts of the employee. Negligent hiring does have a very high standard to prove. Someone trying to bring this cause of action has to prove that the employee that took the negative action was unfit from the start for the job that they're hired for, and that the employer was fully aware that they weren't fit to be doing this job. They then have to prove that the employee created an unreasonable risk of harm to others, not just a potential risk, but an unreasonable, unjustifiable risk. And then the third and final element that must be proven in these cases is that the employer's direct hiring of that employee was the causal link of that harm. That if it weren't for the hiring of that employee, this harm would not have occurred. Because of all these elements that someone trying to bring this claim has to prove, it's a very, very high standard to try to bring a successful negligent hiring claim. So employers should not be overly concerned that this claim is going to be used against them if they're doing their due diligence to check employees and check for successive rehabilitation. Additionally, a lot of research has suggested that those companies that do hire returning citizens, the reasons that they were let go were not for committing crimes on the job. They were for other reasons. And harking back to some of the factors that Josh mentioned, the soft factors, there's high loyalty for returning citizens who are hired by employers. There is that chance of further rehabilitation and skills training. So employers looking to hire returning citizens should not be overly concerned with negligent hiring. For the final slide, moving on to the next one, those employers who are still concerned, though, have avenues to address their concerns about liability. As Josh briefly brought up, the Federal Fidelity Bonding Program is designed for employers who are looking to hire these at-risk or concerned employees, which includes the category of returning citizens. This is a partnership between the U.S. Department of Labor and Union Insurance Group, and it is free to employers to cover the first 6 months of employment, and employers can purchase additional coverage if they'd like to later. So this program protects employers who have hired returning citizens or other considered at-risk employees against any acts of dishonesty that could potentially lead to liability for the employer. Here in Michigan, the Michigan Works Agency Service Centers each have a specified bonding coordinator who can begin the process of issuing a bond once they've been contacted to an employer to become engaged in this program. Some of the specific requirements for this program are that the worker must meet the state's legal age for working. The workers must be paid wages with federal taxes automatically withheld and deducted from the pay. The employer must make the applicant a job offer and set a date for employment, and the employment must be contingent on this bond being issued. And then bonds can also be issued for current employees as well, who have maybe come up with a negative instance at work and need this bond in order to prevent being laid off, or if they're trying to move up in the company and the employer would like a little reassurance to secure a promotion or higher position within the company, these bonds can also be applied to. Finally, the employee must be hired for a minimum of 30 hours a week for a consecutive period of 6 months. All jobs are bondable both in the private and public sectors, whether it's full or part-time, as long as that part-time is hitting the 30-hour requirement, and as well as jobs secured through temporary agencies. Again, the Michigan Works Agency is the contact point for anyone interested in securing one of these bonds, and more information can be found at hirenetwork.org or mitalent.org/bonding. Moving on to some of the other programs and decisions that employers can take is going to be Taylor discussing company culture solutions to welcome returning citizens.
Thank you, Hannah. So companies can, and many are, taking various efforts to relax restrictions on hiring returning citizens while embracing fair chance hiring practices. Two leading practices that we'll discuss today are efforts to move and or ban the box, as well as the ability for employers to join fair housing partnerships. Now, starting with ban the box, these efforts involve delaying or foregoing questions of an applicant's criminal history, and this ensures that returning citizens have a fair chance to show their skills and qualifications without being automatically barred from consideration because of their criminal history. One example is Walmart, which is actually the nation's largest employer. And specifically at Walmart, the company has removed questions about criminal history from its employment application. The company conducts a background check only after a conditional offer is made, and they have a vetting team in place to consider individuals' total profile and qualifications, including rehabilitation efforts and other mitigating factors. So questions of criminal history may still be important for companies and necessary for an employer to ask, but delaying these questions can facilitate more nuanced and individualized assessments of a candidate's history. Both the state of Michigan and Oakland County have ban the box laws in place that mandates this action on behalf of government employees, while the city of Detroit has a similar ordinance that applies ban the box to certain city contractors as well. Now, while most private employers aren't mandated to take these actions, you can see from my Walmart example that many are taking their own initiative in this respect. Now, moving to the next slide, there are a number of factors companies should consider to get a more holistic view of a candidate's criminal history. And for those of you that may not be able to view our slides, these factors include the number of offenses, the age when a person may have been convicted or released, as well as their behavior after conviction, including rehabilitation, any references they may get from community members, and their consistency of prior employment as well. Now, finally, moving to my last slide, there are a number of organizations locally and nationally that support and provide resources for businesses that are committed to practicing these inclusive hiring efforts. So, for example, businesses that are welcoming to returning citizens can work with the Pure Michigan Talent Connect, and this will allow them to both advertise opportunities and better find worthy applicants. Now, you can see I have a couple other examples up here, but now I'm going to turn things over to John, who will wrap up our presentation.
Thanks, Taylor. So just to wrap things up, we gave you an introduction and an overview of who we are, Wayne State University Law School Business and Community Law Clinic, and the different projects that we've worked on. We gave you an overview of different business organization forms and entity types, both for Michigan companies and Delaware companies. And then we talked about our special topic, which is returning citizens in the workforce and how to combat barriers to reentry, especially citizens who are returning as entrepreneurs and organizations engaging these returning citizens. And if you have any questions, if you have any further questions, comments about the presentation, please send us an email at bclclinic@wayne.edu. So that's bclclinic@wayne.edu. And we will respond as soon as we are able. And thank you for attending. We all hope that you stay healthy and enjoyed our presentation. Thanks.
Just want to thank you guys so much. Thank all the student attorneys and their advisors for giving this great presentation today. I know that there was a lot of material there and not everybody has been able to view the slideshow. So this is something we don't usually do with these presentations, but we recorded this session with the caveat that this is not official legal advice and that these are up to date as of April 3rd, 2020. But with that being said, it's going to be available on our website at go.umflint.edu. And again, if you have any additional questions that you'd like to send to the student attorneys to have answered, please email them at bclclinic@wayne.edu. Thank you guys so much for joining us today, and we look forward to having you join us on the next webinar.
Thank you.
Thanks, Nick.
Thank you.
Thank you.